we are hearing from Andrew Brouwer from the Refugee Lawyers Association.
Thanks very much. I am going to focus my comments today on timeline issues. We've sort of split up the issues. Many of the advocates have very similar fundamental concerns about this bill. So I'm going to start now just by talking about the front end of the refugee determination system, what this bill does to that front end of the process, and why we see some problems there. So I'm here speaking on behalf of the Refugee Lawyers Association, which is a voluntary association of about 200 refugee lawyers in Ontario. So just to understand how the system works right now for those who aren't actively engaged in this area, when a person comes to Canada and starts a refugee claim, they have 28 days from the day they first say, please protect me from sending me back to persecution or torture. They have 28 days to find themselves a lawyer and legal aid, presumably, and set out their case, explain why they're in danger in their countries back home. Well, 28 days to find a lawyer, get an interpreter, figure out the system here isn't a whole lot of time. It generally, not always, but it generally works. Those who are lucky manage to get legal aid first and get themselves to a competent lawyer. And then they sit down with a lawyer. And I can tell you from my experience, and I'm sure this is shared by my colleagues, sitting down with a refugee who's just come to Canada, particularly a middle-aged white guy, asking them to explain to me in their countries what happened to them and why they fled, why they can't go back, particularly where the claim raises issues around, for example, sexual abuse, taboo sorts of issues, maybe sexual orientation-based claims where people aren't even out with their families yet, much less to some guy in another language with an interpreter who says he's on their side. So it's a difficult process. In my experience, you don't sit down once for a couple of hours and get somebody's story. There are multiple sittings. Sometimes you just have a first meeting for a couple of hours to get to know each other a little bit, try to build some trust. You meet again a few days later, maybe again a week later, and then one last time to go through the story to make sure everything's okay. They're really comfortable with the story, the way it's set out. Once the story has been set out in paper, it gets filed at the Immigration and Refugee Board, and then we wait to hear from the board for a date for the hearing. Now, of course, waiting doesn't literally mean waiting. There's lots to do in the meantime. At this point, all we've done is have the claimant set out the reasons they can't go back. Over the next few months, we work with our clients to gather the evidence that they need to support their case. And gathering evidence could include a whole range of different kinds of documents. It could mean just identity documents from their country of origin. It may be police certificates, copies of medical reports if they had medical issues associated with abuse or torture that they sustained in their country of origin. It may mean getting sworn statements from witnesses, people who saw them getting abducted, for example. These are complicated steps to take. And of course, depending on the type of evidence we need for a particular case and the on-the-ground reality in the country where the person came from, you're going to see a wide range in the length of time and the complications involved in gathering and obtaining that evidence. So if you imagine that someone comes into your office and they just came from North Korea and they have no documents because they fled by foot into China and then came using false documents to Canada, we have to prove that this person is North Korean to begin with, and then try to get other documents showing who they are, maybe some sort of proof of their military service, other kinds of documents. North Korea is, in my experience, the most closed society on earth, and getting anything from a place like North Korea is almost impossible. When you do get something, it takes many months and requires a great deal of courage and creativity from the client and their family members, who often have to smuggle documents from one place to another. Similar stories with Eritrea and many other parts of the world. If you imagine, for example, Haiti today, a refugee coming from there, how are they going to get proof of what happened to them? Medical documents, find a witness to what happened. Same with Afghanistan. So it's a long complicated procedure. As well, that time from the date someone starts their claim to the time that they actually appear before the Refugee Board to explain why they're in danger is often used in the cases of survivors of torture or other kinds of abuse to get them some counseling and get them to, for example, a psychologist who can write a report talking about exactly what the impact on this person has been. That's essential both as proof of what happened, but also when this person is then before a decision maker, the decision maker needs to know, I can't be confrontational with this person. I need to treat this person as someone who has gone through what this person has just gone through. All of that said, I'd say in my experience at least, 6 months normally is about enough time to gather evidence, but certainly not in every case. It depends a lot, of course, on the competency of the lawyer and of the consultant. There are those who simply file a refugee claim and then do nothing until a hearing gets set, and then suddenly scramble to gather evidence. In those cases, the refugees find themselves at a serious disadvantage. The delays, though, are far beyond the 6 months that we need. Right now, we have delays in refugee claims from the time of filing to the time of hearing, upwards of a year, sometimes 2 years. I had an Iraqi case where they were waiting for 3 years just to get a hearing to explain their case. When we finally got before a board member, it was done in half an hour. It was such an obvious case. So the delays cause hardship both for the clients and for their family members overseas who are often sitting in camps, waiting for the principal applicant to get accepted so that they can finally come and join the mother, or the father, sibling, or whatever. So that's what we have right now. Those delays, in my opinion, are largely because of, at least recently, the Conservatives' failure to appoint enough board members to hear cases. So we have a growing backlog of refugee claims that simply aren't getting hearings for years because people are retiring from the board or not getting reappointed, and Minister Kenney has failed to regularly and quickly reappoint board members or appoint new board members to fill spots. And then comes the new bill, Bill C-11, which is proposed as fast and fair, or a balanced refugee reform. The bill, at least what I'm going to talk about it, and I'm not going to be a whole lot longer, I know. There are two particularly important aspects related to timing. One is a promise of $500 million more for the refugee system, and two new steps. Well, one new step and a commitment to faster processing. Under the bill, rather than having refugees come and sit with counsel for multiple meetings to develop their story and to get it from them, 8 days after arrival, they will meet with an officer from the Immigration and Refugee Board, and they'll be expected to tell that officer why they're in danger and what happened to them. Then, 60 days after that, they'll be called in for the hearing. From what I just told you about my experience, at least, of developing refugee claims, working with clients, and of gathering evidence, neither of these timelines works. Practically speaking, what's going to happen is you'll have refugees who just aren't ready to tell their story before a refugee board officer who will take whatever they're able to say, and that will become the basis of their refugee claim. They may, after that, get counsel. We as counsel may attend a hearing with them, but at that point, it's too late. They're on record saying, you know, there's only a few things that are wrong. We go with them 60 days later to present their full case. The board member won't believe it. This happens all the time. If they didn't say the whole story right up front, when we go later and try to give the entire story, it gets rejected. People will be found not credible for inappropriate reasons. I thought I could do this in 8 minutes.
Well, there will be more time during the questioning for you to bring up further points.
Sure, I will. I think those are the fundamental issues on timing, and I will pass on.